Hi everybody. Let's review our newest course offering from yourlaw.org. We like to call it Legal Word Power Mastery Class. So why does having mastery of language matter when it comes to a legal situation? Well, let's face it, it's all about the words or the lack thereof. And we're going to show you a unique way to deal with legal issues, almost any legal issue, far distant from the other things you might have seen out there. What we're offering is a 8 to 10 week online course, and we're going to teach you how to stop arguing, try to stay out of their courts, and instead start correcting and disqualifying their non-legal contracts, because courts are merely about contracts. That's really what you're going into today. They're all commercial enterprises with tax ID numbers, and they're doing business, whether you believe that or not. Many are caught up in legal battles. They will probably lose 98% of the time, maybe even more likely with an attorney, which isn't to disparage the attorneys, it's just the way the system is set up. Really, we want you to understand some basic procedural knowledge and discovery questions that you can ask. Hiring an attorney is usually just a negotiation to lose and a waiving of a whole lot of things that you could do on your own. So what we do is we call them out for using language fraud, and you do this by yourself. Once you know the basics of how to do this, it's not that hard. It will take you some time to learn. This class will take some effort, but I assure you, you'll never look at anything the same way again. You won't be trying to understand statutes and codes and too many procedures. You'll know a few procedures, but it'll be much simpler as a fresh way to look at everything that's going on in your life legally. And every day you walk out your front door, you're dealing with legal issues, whether you want to believe it or not. And simply calling somebody else is not the solution. Your knowledge is the solution. See, there never really is a valid contract unless there are two like parties involved. And they kind of get you to walk in and set yourself up into a situation where they can presume that to be true. So our key to winning is simply not to play. And now the example you're seeing on your screen here is really a defective mortgage. And frankly, every mortgage we've ever looked at is defective by the same measure. There are a lot of words in here. There are a lot of formats being used which actually invalidate the sentence that you see on the document. Wherever you see a marking, there's a reason for that. And we'll get into this in the training as to how to identify these things. For example, something that's within brackets or in a parentheses sign or within quotes quite often is actually an omission from the document which alters the remaining document. Where we put numbers on the page, those are small examples of using future and past tense words in the same sentence. Where certain words are used that are undefined. And have you ever seen a list of definitions whenever they hand you a document for court or a traffic ticket? I don't think so. Yet, for there to be a contract, it's got to be defined. But they don't do it. So there's a lot of defects in their documents that most people just assume are okay because they put it into a legal document. You got to stop assuming those things. This is an example of a judgment. This has already gone all the way through the court system, gotten a judgment filed, yet what if the judgment document itself is defective? It is a contract. It says what you've now pled to, you've agreed to, what you're willing to pay in terms of time, energy, or money. And I apologize if on screen you can't read all this. It's just the scale doesn't quite work for the video. But on our live classes, you'll see some more examples of these things. But you see, it's never even too late to use this. Because if a judgment is based upon something defective, then that judgment is void. And that's it. However, it doesn't mean they're just going to lay down. You've got to understand why it's void and then how to proceed to do some things about it. They will never make it easy. But at least if you know you're right, you can get progress done. So what language do you need to know to communicate with the legal system? Well, one of those languages is the language of postal laws, and it's not that complicated to get. They apply worldwide by treaty. Every country that moves mail through the planet, even all forms of communications, are regulated through the postal system. That would mean every contract that's ever generated and pass through the mail at some point. So language fraud equals postal fraud, and that's whether it's done electronically or in writing. Therefore, contract language fraud is a violation internationally. So whatever country you're in, you can take advantage of this training. All communication is effectively a postal matter. And we'll show you the postal manual where it outlines the broad range of which things the International Postal Union, Universal Postal Union that is, regulates. And by treaty, these things fall under their authority. And they have some of the most powerful courts in the world, way beyond those lower courts that we deal with here in our country. So just asking and raising these issues is a powerful technique. Once you raise the question, they owe you an answer. And you're not asking about, what is this? I think the statute says this or the code says that. It's really not meant for you to understand, because it's not written in a language that even most lawyers can understand, quite frankly. So what we're basically talking about here is what is a contract and what is not. If they have to have a contract to move forward with you through their process, then we have to identify that there is no contract. It's not just to go in there and say, where's the contract, or say there's no contract. It is to simply understand that all contract is law and law is contract. And if you go back, that even applies to the Constitution. Even has an article in there about they can't abridge contracts. So it is a contract. Now, if there's no contract, then there's no law and therefore no jurisdiction. Once you establish there's no contract, the court itself loses jurisdiction. Now, you have to know this, but then you have to know what to do with that information, of course. And once you understand that, that's the game you need to know. You don't need to know the statutes and codes and the hairline things that might have gone wrong. You just have to understand that if there's no jurisdiction, there's no jurisdiction. Now, let me put a warning out here. Warning, big warning. If you caused a harm to another person, a lot of these rules don't apply, because that's what's called common law. It's a do no harm clause in the law. If you've caused a harm or you even endangered someone, maybe you didn't cause them a harm, but you did do something foolish to endanger them, well then you probably need to deal with that. And many of the techniques we talk about here do not apply. This is not a way of getting away with something. It's a matter of simply asking for correction. And if the other party cannot provide that correction, then they have a defect in their case. So this is all about defects. Okay? It's not about getting away with something. If anybody assumes that, you're just simply playing wrong. Because once common law kicks in, it gets a lot more, it changes things quite a bit. So let's talk about contracts, though. We're talking about mostly those situations where some agency or attorney is just coming after you for some piece of paper. So we need to understand the power of words and what's going on in court. One must first know that all civil and criminal courts today are contract courts under the rules of admiralty maritime. And sometimes they refer to those as statutes. Those are also admiralty maritime terms. And they're effectively only dealing with contracts, or really a lack thereof in most cases. In actuality, due to fictitious conveyance of language, you're going to learn that word and hear that a lot in our class, that they are using on people with words that are not clearly defined within the documents being presented, there is no contract. And I'm going to cover that in just a minute, so stay tuned. There is only offer and acceptance by default. And they'll come in and offer you something, and if you accept it, then you just entered into an agreement, but it's not a contract. Therefore, be careful what you consent to. Rarely is there a valid contract, and therefore is the authority or jurisdiction proven and authenticated by material fact witness? Well, no, it's not. Unless you accept their defective offer. And this is what they train you to do all the time, because we go in there and we're afraid and we don't use our common sense. It's an offer, not a contract. Elements of contract and what they are really doing to you. So you have to know the game that is really going on. It's not going to be what's right there in front of you and what you think is happening. If you go take what I'm teaching you here and go sit in on some arraignments of criminal arraignments, go find a courthouse near you, go sit in and watch it, and keep in mind that they're going to implement these elements of contract in there, or at least they're going to get people to accept. But let's ask some questions as we go through that process. So first of all, 1. parties competent to contract? The parties to a contract should be competent, being of age of consent and sound mind, not disqualified from contracting by law to which he or she is subject. A flaw in capacity may be due to minority, lunacy, idiocy, drunkenness, or dissimilarity of kind. The parties should be of the same kind. This is very important. Being either legal fiction actors or living men or women. You can't be both. You can't mix. So this allowing more than two parties, but never a mixture of these kinds in their respective jurisdictions. When they come into court, they're going to call you by a legal name, not by your given name. That legal name is a recorded fictional entity with the Secretary of State, right along with other corporations, where they house your birth certificates. Go down to your department where you get birth certificates and just take a look and watch what's going on. It's there with all the other corporations. When they're identifying you, they're asking if you will stand in for and be the corporation, not you. This is a hard concept for a lot of people to get. I'm trying to keep this as simple as possible. Everything, look at your mail, look at your documents, look at your driver's license, look at all the basic legal things that they put on you, and they're going to either use a fictional name that would probably be all capital letters or something with a middle initial, or maybe not even listed the way it was actually listed on your original hospital birth record, which is last name, comma, first, middle. That's how it's usually done on that original document. But then they switch it and create a legal entity for you to manage your estate through. It's that estate that they're after, not you. So are you a mere entity or a fictional thing? Well, they go on and try to establish this further. 2. Free and genuine consent. The consent of the parties to the agreement must be free and genuine. The consent of the parties should not be obtained by misrepresentation, fraud, we'll talk about language words they use, undue influence, coercion, they scare you into coming in and doing something, or mistake. If the consent is obtained by any of these means, then the contract is not valid or legally lawfully enforceable. They know this. They know they've done all these things to you when they bring you in under an arrest or into a suit situation quite often. And here's the key. They get you to simply accept an offer rather than bind yourself into a contract, and then you voluntarily proceed. That's when you waive these things. Don't waive these things. Did you know you were consenting voluntarily? Was it clearly explained that this is what was actually going on? Did your attorney even explain it to you this way? And I assure you, I've rarely ever heard one be able to do that. 3. Full disclosure. When negotiating a contract, full disclosure is the step of providing all material information and telling the whole truth about the matter which may influence the decision-making of the other party or parties before they decide to enter into a contract. If either party fails to make full disclosure, the contract is null and void. Now, did they fully disclose all this was going on whenever you had to go to court for something or deal with a legal issue? Probably not. Or deal with a mortgage contract issue or a tax issue, whatever it is. There's always a court going on. It's the piece of paper is the court, and we'll teach you this in the class. It's not the room you go to, it's the paper. The paper itself is called within the four corners rule. If it's not properly in there, there is no court. 4. Valuable consideration. The consideration of something of value possessed by the parties that is brought to the contract table. This something of value is bargained for and given in exchange for a promise or performance. The parties must each receive a benefit from each and suffer a detriment. To be enforceable, a contract must have valuable consideration. A contract is unenforceable if it is insufficient or unequal consideration without agreement. This is why they do offers and acceptance, because with an offer and acceptance, they don't need to bind themselves to a contract. See, they never want to bind themselves to this kind of an agreement or a contract. But they will make you an offer and you can accept it and sign a defective document and rock right into jail or rock right into a suit or a judgment. Okay? They know this is where they can take you because you understand these basic words on this slide you see right here. So they're going to at some point have you give a signature and promise to perform. And when you enter a plea, for example, innocent or not guilty, or you just simply show up saying, I am proceeding as named, You've essentially entered into a agreement somewhat like a contract, but it doesn't meet all these conditions now, does it? 5. Certainty of terms. The terms and conditions of the contract must be fully disclosed and agreed upon and must be certain and fixed. Any subsequent variation of these terms must be agreed. Now ask yourself, did they disclose this when you signed a tax form or driver's license form or some other form with the government? Or when you signed onto a mortgage or a credit card? Yeah, they kind of do, but the words on the document themselves are fictitious and misleading and not defined. So did they disclose? Did they? Did you fully understand it? Fully. Probably not. 6. Meeting of the minds. The meeting of the minds consensus ad ideum occurs between the parties when they recognize each other, understand their mutual obligations, and agree. A meeting of the mind occurs between living men and women in lawful matters, that is under common law, and between legal fiction actors, and that would be your entity name, in legal matters, and that would be in admiralty maritime jurisdiction. A contract must be either lawful or illegal. You can't mix the two. Once a party to a contract makes a signature as an accommodation party to a legal fiction person, which is what they get you to do all the time on all your contracts that you sign or presumed contracts, while the other party makes an autograph for the living man or woman, the parties are of unequal kinds, and the contract is null and void, equaling no contract. So if we don't even get into the very words and language, the very procedures and the parties they're mixing together here are improper, and therefore there is no contract, even though they can still get you to walk right into jail, right? That's because you walk forward under these presumptions of a mere offer and acceptance. Excuse me. So, 7. Autographs and signatures. Lawful written contracts between living men and women must carry the wet ink autographs of the parties, comprising living identifications such as a thumbprint, or more often living standing is recognized by an unambiguous declaration with the handwritten wet ink autograph, including the prefix by, you would by before your name, colon, and or the words all rights reserved or without prejudice written near or below it. When you do this, it alters the signature into a autograph. And by the way, the autograph should be clearly almost printed from what I've seen in the examples. Because then there's no ambiguity as whose name is there, and of course in the format you want it to show. So legal written contracts between legal fiction actors must carry the wedding signatures of the parties as an accommodation from a man or woman. You want to identify you're a man or woman. When you put those words on there, that further identifies it. Does this automatically stop them from messing with you? No, but it gives you a tool to use when you need to bring it up later. So don't expect them to lay down and say, ha ha, you got me. No, you just do it procedurally and you continue to follow up until you win. 8. Privity of contract. A contract exists only between the parties. No third party can obtain rights contained within the contract or buy or sell a contract without the express permission of the original parties. Now remember, you're operating an estate going through commerce, and this court is trying to get themselves into your contract. They want to make themselves a beneficiary of your estate. That's what they're pulling you into court and doing. So, do they actually have the right to do that? And can they even form a contract with you under those terms? No, but they do it all the time. In fact, do they take your documents when you walk in there and you just play the game gullibly, and they'll take your documents and sell them and make a profit on turning them into bonds and selling those things. I've seen this firsthand. I've seen the bonds used in cases I was involved in and in others. And it was never disclosed to these people that they're taking your contract, creating something out of it, and making a profit from it, and not disclosing it. That, folks, is called fraud. And it is fundamentally in every single case, in every single court in America. So, in our studies, we need to take it to the next level. Now that we know these basic contract rules, we need to go down to yet another level of showing how defective these contracts are. Remember at the beginning I showed you these a mortgage document and a judgment. I can show you. You can give me almost any legal document by a court, attorney, or major institution. Not private party contracts. Those are two parties usually of like kind. So this isn't to get out of something. These are the type of agreements where there's really no damaged party over there. There really is no contract. So what we do is we focus on words and syntax. Words are often formed that have a negative meaning, and we'll get into a great deal of in other words, they mean the opposite of what we've been taught they mean. And of course they didn't disclose this. So they use these non-contract words all the time. Then they use symbols such as extra spaces, which is a void continuance of evidence. That's what that's called. Or boxings, where they put things in brackets or quotes or parentheses or a literal box around something. Undefined words. They put words in the, you're not really, you sure you know what that word means? Honestly, do you really think, you want to prove how smart you are, you know the vocabulary? Well, which dictionary did they draw that word from? What if they use multiple dictionaries on the same document? They do it all the time, folks. Then they use codes, coded symbols. Today you see a lot of, scan codes on documents. Well, what does that scan code mean? Did you ever ask? Or you just assume it's just okay? What if that had terms and conditions that you were supposed to know? Was that fully disclosed? Or they use sentences with future and past time tense in them. They do this all the time. Adverb, verb. What if there's no noun in the sentence? We show you how to identify this, and guess what? That sentence has to be removed from the document to be corrected. Then what does the document say? With big empty spaces all over it. You see how this works? You're creating, the document is the court, the document is the tool, and so we want to simply ask questions about it to see if they can qualify the document. I don't make a claim that it's disqualified. I want them to prove it is. Put the burden of proof on the other party. That's how we play the game. So, there's words like defense. Well, what if you found that the DE means no fence, or no protection, no contract? Describe. D is a no meaning. No scribe equals no contract. Defect equals no effect. It's no good, right? Isn't that what we think defect means? There's a word we kind of understand. Well, the DE means the same thing in front of other words too. It means no, and eventually means no contract. That word is a no contract word. It's defective. Comes out. And we can do this to RE, DI. We show you how to use sometimes A, like for example, abnormal means not normal, right? But it also has the same effect on other words out there as well when it's used before a consonant. So we'll show you how to identify those things and then show that that word has to be removed and corrected. If they won't remove and correct, well then you cannot proceed based upon this piece of paper that the whole court is based upon. Because it's defects and you have questions that are unanswered. There's discovery, and that's a lack of due process if they won't give that to you. Now if they move forward based upon that, then you've got grounds for appeal. See, if you don't create grounds for appeal, then you have no appeal. A lot of times people don't understand this. They understand that they think they're going to go to court and win when they understand what they're really there to do is to build a case for appeal. Then they might win because then the court might realize that they're screwed or that you have something real you can go to an appeal or to a higher source with. So here's some traps you want to avoid. They never want to contract because it would bind them and they would realize they're committing you'd be catching them at a fraud because they're trying to contract their fictional entity, which is a corporate entity, a government or whatever, with the living man. They can't really do that. So they had to play this game of getting you to come in and represent a fictional entity to make it appear they have a contract. Even then, though, without full disclosure and consideration, it's valid. So the way they get their immunity is by not contracting with you. This is how they protect their butt. It's why it's so hard to go after a judge or some of these other people because they're operating under some sort of immunity, but in reality it's not immunity if there was fraud involved. That's how you break down that immunity claim. We don't go in there claiming fraud, by the way. We go in there asking questions, and they'll be the ones to reveal it. That's the technique we use. Trap number 2, they use fictitious language and syntax methods and undefined words in their documents that are not English. We think it's English, we think we understand it, but in fact they're using patented, and we will show you in the class, an actual patent for language codes. Sometimes we refer to this as legal coded babble. It sounds like words, but in reality it might even be literally a patented form of structure to scramble the words. I was formerly in naval intelligence, just letting you know. We used to do crypto intelligence and scrambling words, and it's been something that's going on for a long time. But now the legal system uses it against us. They have words that sound like words that have completely different meanings, and we're going to show you how to identify those things and show that it's a no contract language. When they're using these negative words that mean nothing, then their piece of paper within the four corners rule of their document, which is the court itself, is the four corners of the document, is no contract. And they need to correct it. That's all we ask them to do. And until they correct it, we are not proceeding. So the so-called court is the document, docketed and birthed into their port of entry or their room. That's where you walk through the bar. And it's within the four corners of the document that you're there to discuss, nothing else. And this is a technique you go in with this syntax document prepared. And by the way, you will learn that if it's over your head and you want some support, we will offer some. It's a fee-based service to do the forensic analysis and syntaxing. But at the same time, we ultimately want to teach you to be able to do it yourself. And as a matter of fact, we'll show you how to do this as a business, doing the forensic analysis of documents. You'll learn this well enough that you'll be able to do that and actually generate an income from it. So, the key is identify and ask for correction of defects. If something is defective, as it says most cases, I can almost safely say all cases, the document, the case, the ruling is void, period, and can be taken to higher authorities for enforcement. Usually they'll just simply want to avoid it. So don't expect them to easily back down, but with the right approach, they usually renegotiate after the receipt of our polite questions that we raise. And it will likely simply go away, or they're going to give you a great offer, something like super minimal, a little misdemeanor, drop to fourth degree, whatever, just to get it to go away. That might be an acceptable offer, because then at least they don't have to expose. We don't have to. I know you all would like to expose all this fraud, but sometimes it's best just to get out of it and not deal with it. We're not here to destroy the system. We'd sure like the system to correct itself, though. And we are offering ways they can correct themselves and then avoid future frauds. And then, of course, hopefully they leave you alone in the future. And once they know you know how to do this, they're more likely to. So we ask the right question, asking for correction. That's the approach. And we usually can close them down. I had a collections letter that came recently, and literally by the time I mailed back my response with my correction requests, exposing that the amount level of fraud that was involved, I didn't say that, but I just exposed it by asking the questions. They overnighted back a package to me apologizing and saying they would never hear from me again. Please don't. Basically, they're saying, please don't sue us. That's the position you want to always be in. Going into these situations, this technology can help you do that. Literally, they FedExed a package back to me to cancel the claim they were making, but even before the green card for certified mail came back to me. So that's sometimes how quickly they respond to this stuff. So we're going to do this class, and it's going to be ongoing. So if you get here a little late and we've already started, you can kind of restart with us. And we're going to record the session, so it'll be a recorded class as well. Probably 8 to 10 sessions. I'm not 100% sure at this point, but we'll see where it ends up. Plus, there'll be ongoing Q&A, and of course, we record everything. We're going to show you how people have done birth certificate corrections, which you re-notifying the birth record department of how that certificate is to be used and not used going forward. That's a powerful thing, and it's as simple as a one-page document. Passport correction. You don't have to reapply for your passport. You can use either the one you got, or if you do replace it, there's a way you can re-autograph it versus sign it with some technologies that you can add to it to correct it, and to notify anybody you hand it to of your status. because this is also somewhat of a status correction. I don't like that word because it's overused in the sovereign community, but it does notify them of who you are and how you're operating. You can do the same thing with your driver's license or your registrations on your cars. See, we're not running around telling you just to get rid of all this stuff, because sometimes that creates more problems than good. But at least you can get control of these things. It's up to you if you want to get rid of them, but I'm not saying whether you should or shouldn't. I'm simply saying, though, it's a little less complicated sometimes to not go to that extreme. If you have a bank account, we show you how to correct that so they can't sell your data and use your data and use it against you. We're going to go into that. We're going to show you how to create a Live Life claim and a CPAS. Now, these are literally identification documents that, when they're done correctly, will be recognized internationally for transit and for passage. We'll talk about dealing with collections, even sentencing, late matters such as sentencing that's going on, or an indictment, or a suit that's coming after you. All kinds of things that have to do with a fictional entity coming after you. Now, again, if it involves a real party, a living being, something in marriage or in, arguing over who gets the kids, that's a lot more difficult because there's a lot of emotion we can't simply deal with. But sometimes the institutions involved can be dealt with this way. But we're not going to help somebody gain an advantage over an ex or a partner that's dealing with really a lot of personal issues. We're simply dealing with the institutional type of things that come after us, which happen all day long to all of us. We all, every day, are dealing with this. This is why everyone on the planet needs to know this knowledge. This is something that should be taught basically in school, but they're teaching you just the opposite, teaching you how to become speak the language of slaves, as we call it. So we want to help you bypass postal offers. That means something that usually comes through the mail or even hand delivered by government attorneys, bank officers, which includes suits and demands. It might apply to tax agencies, property tax, court orders, judgments, traffic issues, driving licenses, passport. As we just mentioned, there's all kinds of things it might apply to. But if you have an actual bill, an obligation to pay, you need to pay it. But if there's no valid contract, then you have the right to raise that issue. This is very important to get that. If you have a tax due, pay it. But if you have an invalid contract, you at least have the right to question that and to have them prove it first. That's all we're asking you to do. So this is not a way to get out of anything, out of paying a tax or a mortgage or anything. But it is an opportunity to see if they have a valid contract. By the way, if they don't have a valid contract, then there probably isn't really a damaged party. Get it? All right. So we want you to become a premium member of yourlaw.org. You go to yourlaw.org/join for details. If you're not even a free member, you can go sign up first for free, then upgrade to a premium member. But you'll have to be a premium member to watch these trainings and videos and get the support. We won't be answering questions unless you're in the live classes. Or in the weekly Q&A calls we might do as well ongoing. So, and by the way, there may be some third-party material, a few books, some material, references you might want to get to. We like using the self-help legal course because it teaches you procedures. That's yourlaw.org/JD. There's also there's even some material by a guy who has authored a lot of this material, but also doesn't teach it at this level. So we'll give you those reference materials when you get in the class. It's optional, but it will greatly help you if you do use some of those reference materials. Then if you want private consulting or forensic analysis done of documents that you're doing, maybe you've got a business that's getting sued a lot, or you have other issues. We even help attorneys do this because they don't know how to do it. And we do have consult services available as well. So you don't have to go through the class if you don't want. We can just consult you on how to take what we do with you and walk you through it. Although to really do it effectively long term, you really need to know it. Join us and tell a friend. All you need to, it really is just got to know the right questions to ask. Okay, stop playing in their game as much as possible, and use instead ask for correction method. That's what we like to call it. Ask for correction. When we don't go in there and argue, we're not trying to create disputes. We're not saying you don't owe something. We're just asking somebody to validate a contract. And if they don't have one, then we have some rights. It's called due process. So, but also remember, as I mentioned earlier, it's a bonus. If you take this whole course and you really get it, we'll even talk to you about how to turn it into a highly profitable forensic consulting business. This is a high demand thing. It can resolve a lot of contract issues that are going on out there. That may be put together as a small separate module, but will be talked about ongoing because everywhere around you there are people that need this. And they won't have the opportunity to get educated, but they might be able to go through you to get a service performed, and you could earn nice fees for doing forensic analysis. Not legal advice, but forensic analysis of documents. That's all we do too. So anyway, get to urlaw.org/join. Learn more. If you're already a member, get ready for the upcoming classes. If you're a member and this has already been out a while, just go back, find the videos, and start going through the class material. And of course, you can ask questions on our weekly Q&A calls. Until then, nice talking to you.